Well, good morning. Around this time of year, we would usually hope to be in Jersey face-to-face for our annual conference. That, of course, was not to be in 2020, and I would like to welcome you all instead to the first of two webinars that we at Wilberforce are hosting as lockdown continues. This session is aimed at the often overlapping practice areas of insolvency, fraud, and asset recovery, entitled Hard Walls and Ways Around Them, which should hopefully be up on the slide in front of you. First, Claire and I will be talking to you about the rule against reflective loss. And after that, Lexa and Daniel will be talking to you about some arbitration claims by and against insolvent companies. As many of you will no doubt be familiar with by now, there is a question and answer function at the bottom of your screen that we would very much like to encourage you to use across the two halves of this talk today. We're going to pick up questions at the end of each half rather than doing them all at the end. If you could use the question and answer function to do this, we will be very grateful, as opposed to the chat function or the always endearing hands up button, as it will be easier for us to make sure we don't miss you that way. And with that, I will start on the first half. So if I could click on to my next slide. And then the next slide again. That'll be, there we go. So to make sure we're all starting on the same page, the most pithy summary, it seems to me, of the rule against the recovery of reflective loss as a matter of English law is Lord Bingham in Johnson and Gore Wood, a case we'll be coming back to. I've put the quotes up on the screen. The loss claimed appears to be or is one which would be made good if a company had enforced its full rights against the defendant. There is quite a bit packed into that sentence, which we will be unpicking over the next few slides. Now, this, on its face, rather technical sounding rule has taken on a bit of a life of its own. It appears to have an ever wider scope, ever narrower exceptions, and if you are caught by it, your claim is struck out. Given that the use and abuse of companies and their assets is a common feature of insolvency, fraud, and asset recovery claims, this rule has a wide impact on potential claimants. After all, if you have no cause of action, it's going to be rather more difficult to get any interim relief, such as a freezing injunction, off the ground. If I could take on to my next slide. As you will see from some of the examples there have been a lot of decisions in this area in recent years. Most recently, and to date, the only decision of the House of Lords or the Supreme Court was Johnson and Gore Wood in 2001. Since then, there have been a number of decisions of the English Court of Appeal, most recently Marex in 2018. Those have been followed, notably in some other jurisdictions such as Cayman, with two recent decisions of the Cayman Court of Appeal adding to the recent developments of the law in this area. There have also been a raft of decisions at first instance, many of which could be read as attempts to get around the scope of the rule as most recently prescribed by Marex. Now, Marex was heard by a panel of 7 Supreme Court justices in May last year. Judgment seems to have taken them some time, and query whether at this juncture the English law rule will take a different path. If I could, that takes me on to my next slide. Now, rather than take you through all of those cases, it is submitted that there are 5 key points to take away about the modern scope of the rule in English law. And we're hoping that will be an enlightening point of comparison, and Claire then comes on in the next section of our half of this talk to discuss the position in Jersey. So first, the rule is a rule. There is, at least in theory, as there are a number of exceptions I'm going to come on to, no exercise of judicial discretion when it applies. The claim must be struck out. This comes most clearly from the speech of Lord Millett in Johnson. It was also the result in Marex in the English Court of Appeal. Secondly, the rule applies to certain types of remedy, not, generally speaking, certain types of claim or causes of action. In other words, it applies to reflective loss. This is clearest from the decision of the English Court of Appeal in Gardner and Parker shortly after Johnson, where one of the very points on the appeal was whether the rule applied to a claim for breach of fiduciary duty. The answer from Lord Justice Neuberger, as he then was yes, it does. An interesting development in recent years that seems to have sprung out of this is that there are now a line of cases in England and in Cayman where it's been found that there is at least a good arguable case that the rule doesn't catch certain types of injunctive relief or claims seeking specific performance, where the effect of the relief is that the asset is restored to the company and is not paid to the claimant. That takes me on to my next slide and my third and fourth points. So third, the rule is not limited to shareholders claiming a shareholder. This is what most people seem to think the rule is all about when it comes up. That, after all, was the point in Prudential Assurance and Newman in the early 1980s when the English Court of Appeal first recognised the rule. However, that hasn't been the case since Johnson itself. Johnson is one of those very helpful decisions of the House of Lords where none of the law lords agreed with any other expressly on the reflective loss issue, except for Lord Gough, who agreed with Lord Millett. And so there was no majority speech on this issue, only a plurality. Nonetheless, the result in Johnson, and most clearly from the speech of Lord Millett, being the plurality speech, makes Johnson authority that the rule includes claims by a shareholder claiming on the basis of their rights as a creditor. In that case, they were an employee, and they were also claiming to recover part of their pension. And that is because the guts of the claim that they were making against the defendant is that the defendant's actions have meant the company is unable to pay the claimant. And so if the company is made whole by the company bringing a claim, then the guts of the claimant's claim is answered. That the rule extends to a shareholder claiming as creditor was then confirmed by Lord Justice Neuberger in the Gardner case I've already mentioned. That then brings us up to date to Marex, the most recent decision of the English Court of Appeal in 2018, which tells us that it includes a claim by a creditor that is not a shareholder and has never been one. Now that was a view that had already been expressed obiter by Neuberger and Gardner and by Lady Justice Arden, she then was, in a second outing in Johnson to the Court of Appeal. So there is quite a weight of authority behind the view reached by the Court of Appeal in Marex, and it would be fair to say that the Court of Appeal in Marex largely thought it was simply following a path it had been set by Johnson, rather than itself being a radical departure. And that may play into how the Supreme Court feels able, or what the Supreme Court decides in when we finally hear from it. Now, fourthly, the rationale behind the rule is said to be based in a number of policy considerations, and you often see these discussed in cases considering the scope of the rule. Authority for all of these can be found across the speeches in Johnson, but they are conveniently listed as 4 points in Marex at paragraph 32, as I've put up on the slide. Marex held that these policy considerations applied equally to a claim by a creditor who was not a shareholder as they did to a claim by a shareholder. And those are, in short, the need to avoid double recovery, a causation argument, the point being that the real cause is that the company hasn't sued, for example, to recover the assets, and that's the real cause of the loss. There is said to be a policy of encouraging settlement and minimizing the risk of conflicts of interest that might arise if you allowed shareholders and creditors to bring claims. And if that all sounds like a bit of a muddle, or that it's not quite clear what's driving the bus, that's because this particular policy consideration seems to be set out in lots of different ways across all of the different judgments. It's not quite clear what the nub of it is. Lastly, and most persuasively, it seems to me, and also it seems to me really 2 points, there is the need to preserve company autonomy and to avoid prejudice to minority shareholders and other creditors. In other words, to stop one claimant stealing a march on all of the others. And that takes me on to my last slide, and the fifth of my 5 points. The rule has only a few narrow exceptions, and it is some ways here that we really see how wide a scope the rule now has. Firstly, where the company itself has no cause of action. This was set up by Lord Bingham in his speech in Johnson, and that speech has been widely followed since. However, it's important to appreciate that this includes more than you might think, or excludes more than you might think, depending on how you're thinking about it. The company having a cause of action, and so the exception not applying, includes where the company has settled the claim, or perhaps at an extremely low sum that you think is far too low. That doesn't mean you can say, oh, well, the company settled its claim now, it doesn't have a cause of action. That still meant the company had a claim and you can't sue. You're still barred by the rule. Similarly, where the company just never brings the claim, indeed to the point where its claim gets barred by limitation, that still doesn't mean you can say the company has no claim. So, second exception, the claimant is owed separate and distinct duties and has suffered a separate and distinct loss. Now, conceptually, that makes complete sense and is easy to say. It's again set out by Lord Bingham in his speech in Johnson, which again has been widely quoted and followed since. Now, this has succeeded in a few recent cases and seems to be the main line of attack that is being taken post-Marex. I've put some examples of that. No, I haven't actually in the end, as they wouldn't quite fit and I didn't want to overwhelm you with information. But some examples of that include a recent decision of UCP and Nectris, which is up on the earlier slide, which was a claim pursuant to a three-party contract. There was also the other claim I put up on the earlier slide, Zedra and Hutt, where this succeeded, but it has failed in other recent cases, so it's far from a silver bullet. And each of those cases turns very much on their particular facts, so I'm not sure how helpful it is to set them all out individually. The third exception is then Giles and Rind, which comes out of a decision of the Court of Appeal in England very shortly after the decision in Johnson. This might loosely be described as a fraud exception. What if the defendant's wrongdoing left the company unable to claim? Now, it's only successfully been applied in 3 cases, and those are up on this slide. That's Perry and Day at first instance in 2005, Giles and Rind itself in the Court of Appeal a few years before that, and the very recent decision of Calakis. Marex held that the test, which was notably satisfied in all 3 of those cases, was that, firstly, the claim by the company is legally impossible. It's not enough that it's factually impossible. Secondly, the defendant's wrongdoing has to have caused those circumstances, that state of affairs. And so while it might loosely be described as a fraud exception, we see that it is actually much, much narrower than that. I note, lastly, that the judge, Mr. Justice Mayles, as he then was, in St Vincent and Robinson, which was a case in which Clare appeared as counsel, questioned whether there was a third requirement, that the defendant also had to intend that outcome. Now, that was the case on the facts of Giles and Rind itself, but Mr. Justice Mayles noted that this was not supported by the consideration of the extent of this exception in the Gardner case I've mentioned, and notably since that decision in St Vincent, Marex has suggested there are just these 2 requirements, but it's another potential limit floating in the background, and the exception in Giles and Rind is part of the appeal in Marex to the Supreme Court, and so it may be that we will hear more about that once we hear from the Supreme Court. But those are my 5 points. I mean, in summary, they are, firstly, the rule is a rule, it's not a discretion. Secondly, the rule applies to certain types of remedy, not, generally speaking, certain types of claim or causes of action. Thirdly, it is not limited to shareholders claiming a shareholder. Fourthly, the rationale behind the rule is said to be based in a number of policy considerations, and you can use these to argue about whether or not it applies. Fifthly, the rule has only a few narrow exceptions. And so with all of that, and given the difficulties that throws in the face of a claimant in a fraud or insolvency case, you might ask if a sense of wider perspective has been lost. And with that, I will hand over to Claire and click on to the next slide.
Right, hello. This is the first time I've done one of these virtual seminars, so forgive me if I cock it up. I will try very hard not to, and apologies in advance if you hear rabid dogs in the background. That is because I do have 2 rabid dogs. Right, reflective loss. I'm a very sad person because reflective loss is one of my pet subjects. Jamie has summarised the principles in England very clearly and succinctly. The position in Jersey is a little bit more nuanced. The only case I'm aware of, and I'm happy, pleased to be enlightened if there's more learning out there, is Freeman and Ansbacher, which is a case from 2009, Sir Michael Burt, then the deputy bailiff. It was a case where, as I'm sure most of you know, there was a claim by a minor who was a discretionary object of a wide discretionary trust. The trust owned, as is standard, a company, and the company had various directors over time who weren't in fact the trustee itself. And that I think is important in understanding whether in reality there's a difference between English law and Jersey law, and I'm not convinced there is. But anyway, the losses, there was considerable losses suffered by the trust company, the underlying company, and the beneficiary sought to claim that the trustees had, in breach of their Bartlett duty, failed to supervise the actions of the directors and thus were liable to reconstitute the trust fund referable to the loss in the value of the company. It's a strange case because looked at through the lens of an English lawyer who loves reflective loss. I don't think this was a reflective loss case at all, because the directors against whom the company's claim would have been made weren't the trustee, and so I don't actually see that there was a risk of double liability, or there was, however, a risk of double recovery. I'll come to that in a minute. Now, in Gardner and Parker, as Jamie's explained, the Court of Appeal said, and it's been since upheld, and let's see what the Supreme Court has to say about it, that the rule against reflective loss is not concerned with the nature of the causes of action. It's concerned with the duplicity of the loss, the fact that loss is being claimed by, usually by a shareholder, referable to the loss suffered by the company, and that's the principle in Gardner. And if that's right, of course, then in Jersey, if it were to apply English law, then the rule against reflective loss in all its rigour should apply in Jersey as well. And the reason I think it should do is a matter of principle, but ultimately, of course, we'll have to see how the courts in Jersey deal with it. Now, the starting point for Jersey is that the deputy bailiff said that the rule in Prudential and Newman applies generally. And you'll remember that Prudential and Newman, a case which we often don't look at because we're more interested in the recent analysis by cases over the last few years, but it's a really instructive case. It dealt with, in reality, the rule against Foss and Harbottle, which is that a shareholder can't bring an action to complain of the irregular conduct of the company's affairs by the directors. The company needs to bring that claim, and the reason is obvious, because of double liability and double recovery and the prejudice to creditors if shareholders can sue and recoup the loss directly. And in Prudential, the facts are instructive because it was a minority shareholder suing the directors, not for their internal conduct as directors, but in deceit. So it was in effect, it was a kind of conspiracy claim, but the way it's reported in the law reports is that the claim was in deceit for a fraudulent circular sent out by the directors. So the shareholders plainly had a direct claim against the directors. But the loss they claimed was loss referable to their value in their shares in the company. And so it fell smack bang into the middle of reflective loss, and they were prevented from claiming it. They had to bring a derivative action. Now, in Ansbacher, Sir Michael Burt said that there's although this prudential principle applies in Jersey, there's uncertainty, and because it was a strikeout application, he didn't need to go further than up the arguability threshold. he said there's an uncertainty as to whether the prudential principle applies in relation to claims against trustees for failing to supervise directors. He wasn't convinced that all of the English cases, which had mentioned, often fairly elliptically, claims in breach of trust, he wasn't convinced that those cases were applicable and relevant where the claim was made by a beneficiary of a discretionary trust. And he also, I think principally his reason for this was that public policy objections, which often prevent reflective loss claims from succeeding, or certainly underlie the reason for rejecting them, is the risk that the defendant will be doubly liable, and the risk that the shareholder will recover twice. And Sir Michael Burt said, actually, there's a way around this. What we do as a court of equity with a very flexible ability to give remedies is we order the trustee who's liable for breach of duty to supervise to pay compensation directly to that part of the trust which has suffered the loss. In this case, it would be the company. So the trustee would reconstitute the company with its losses, and the company, if there are creditors, would then have to pay out the creditors before there could be any distribution to the beneficiaries. So there'd be no risk of creditors being prejudiced. And also, he said, there wouldn't be a risk of double liability, because the company, having been reconstituted, wouldn't then be able to sue the directors, assuming the directors are the trustees, so reflective loss kicks in. That the company wouldn't be able to sue them because it's been compensated, hasn't suffered any loss. And that seems to me to be a very sensible and pragmatic way to deal with it. He agreed in this respect with Walker and Stones, which is a decision which has not found favour with the cases in England since then, that the result of applying reflective loss could leave the beneficiaries without an easy to achieve remedy. But I just question actually whether the rule against reflective loss is really going to be applicable in most trust structures, as the learned deputy bailiff thought. He said, well, most underlying companies have as directors the same people who are directors of the trustee. That, I don't think, takes the matter much further, because you wouldn't be suing the directors as a beneficiary. You wouldn't be suing the directors of the trustee, you'd be suing the trustee. So I don't think that's a problem with it. But also, I think in reality, offshore structures which own companies at the bottom of the tree tend to have corporate directors, which are separate entities from the corporate trustee. And so there's no alignment, there's no defendant who's going to be sued twice for the same loss. So I think the potential problem, though, is that if the trustee is allowed to be sued and it reconstitutes the trust fund, otherwise than in the way that Sir Michael Burt suggested, you'll find a situation where the company still has suffered the loss and hasn't been made whole, and so it could sue the directors. And so there would need to be some mechanism found, and it's not beyond the wit of judges to do so, to ensure that the company is tied into the proceedings in some way, and that compensation does have to be directed into that portion of the trust fund. So it will be interesting to see when we get a decision where reflective loss is truly applicable, and as I say, I don't think it was in Freeman, whether the court will in Jersey take an entirely different road from that in England. And on that note, I'm finished. I think we're over to questions. Jamie, I'll let you deal with those. You're still on mute.
Very good point. Thank you, Claire. Easily done. There is a question in from Caroline Harbord, which I'm going to click the answer live button on, which will hopefully mean that this will appear on everyone's screen. But I'll read it out just in case. Anyway, Caroline says, hi there, can you give an example of Jamie's rule 2? And I think by this, you are referring to when I was saying that there's been some interesting recent cases trying to get around the fact that the rule appears to be aimed at, perhaps at its narrowest, damages payable to the claimant. And this ties into some of what Claire was just talking about, and the possibility that things might work differently where you've got an equitable claim and there's a discretion, or the judge might think they have a discretion to order a different kind of relief. You're not in the straitjacket that the claimant is showing up saying, I'm entitled as of right to damages. And some of these recent cases include, there's a decision of Peak Hotels and Tarek in the Chancery Division in front of Mr. Justice Burse. And he held that there was at least a good arguable case that the claimant was entitled to a mandatory injunction to restore assets to the company. They don't have to necessarily claim in the shoes of the company itself. So one option to get around the rule, and there are a few, one being the possible approach if you're in a fact pattern, as Claire was discussing. Another is if you're in a shareholder position, you might be able to bring a derivative claim. But if that's not an option to you, you might be able to claim as yourself, as it were, to seek these different kinds of relief. And that's been developed since the Peak Hotels case in the Latin American and Maroil case in front of Mr. Justice Tier, where it was held that the claimant was entitled to a freezing injunction, and their cause of action was that they were seeking specific performance of an obligation in a contract. But whereby the sums, again, wouldn't be paid to them, the claimant, they'd be paid to the company. And then those cases have been considered by the Cayman Court of Appeal in the still relatively recent decision of Zykan, where it was held that a qua timets injunction to prevent assets being dissipated from the company also evaded the rule. And that was, again, to the good arguable case standard. Well, actually, that one was to the strikeout standard. It's never entirely clear to me to what extent there is a difference between two, but a notable feature of those three cases, as I have just indicated, is all of them were decided to either the strikeout or good arguable case standard. And so it may be, if you are planning a strategy based on them at the moment, that one of them will go a different way when they go to trial. Another point to bear in mind is that while they may give you your good arguable case to get a freezer off your own back without having to have perhaps obtained the necessary relief to bring a derivative claim, you may do all of the hard work and win at trial, only for all of the company's other creditors to pile in for their pari passu share. And so query if this is the most attractive way to do things. For now, pending the decision of the Supreme Court, it may be the only option open to you. But following the Supreme Court, it may be that this line of case law falls away. But I hope that has given you some examples of the kinds of thing that I had in mind.
Yeah, can I sort of supplement that? Caroline, the rule against reflective loss, and what Jamie is dealing with in 2, is that the rule prevents claims for losses. So if you're a claimant suing for damages, suing for an account, suing for restitution, reconstitution of a trust fund, restitution, any kind of claim which involves money, if it's reflective, it's barred. If you're making a claim for something which is not money, for example, an injunction or an order that the defendant compensate the company, the reflective loss rule is not engaged.
Precisely. I think that has far more succinctly summarised exactly what I was driving at.
It hasn't, but...
Well, I think, so as not to eat into Lexa and Daniel's time, I think it's time for us to move on to the second half of our talk, At this point, Claire and I will turn off our cameras, and hopefully Lexa and Daniel will appear before your very eyes. And there they are, and I'll hand over to them.
Hello, everyone. So I'm Lexa Hilliard, and I'd like to introduce Dan Lewis, who I'm delighted to say that he recently joined Wilberforce, and he's a hugely experienced insolvency and company law practitioner. In fact, I don't relish being against him, so that's how successful he is. Anyway, we've had a lot of fun putting together this webinar for you, and I hope you'll enjoy it. What we're talking about, as you can see, is arbitration and the interconnection between arbitration and insolvency. And if we can just move on to the second slide, you'll see that what we've got is we've got an outline for you. We're dealing with 3 stages. The first stage we're going to discuss is where you've got petitions to wind up, where the alleged debt is due under a contract which is subject to an arbitration clause. Then the second stage is where you've got existing insolvency proceedings of one kind or another, but they have been preceded by arbitral proceedings. And then we've got the third stage where we've already, the company is in a form of insolvency proceedings, and the issue is whether one can have arbitral proceedings that are commenced after the company has gone into some form of insolvency proceedings. We've got a lot to cover. We probably won't cover everything in as much detail as we'd like, but we'll try and get through it anyway. And I'm going to hand over to Dan, who's going to kick off with petitions to wind up. So there's stage 1.
Well, before I do that, Lexa, I should thank you for your incredibly generous introduction. I think it's relevant to note that the first time that you and I met in court, we were arguing about a disputed proof of debt that was subject to an arbitration clause in Hong Kong or Singapore, I can't remember which. But what I do remember is on that occasion, I came very much second. So that lives with me to this day, obviously. Obviously, I've adopted the approach that if you can't beat them, join them. One of the things that, just before we get into the first stage that we're looking at in our sort of taxonomy here, one of the things I think is interesting about this area is just how dynamic it's been over the last few months, because we have one decision from the Court of Appeal in Singapore, a significant decision in April. Last week we had a decision of the Chancellor granting permission to appeal on the Salford principles, permission to appeal to the Court of Appeal. And then yesterday, in fact, we had a decision from the Supreme Court on adjudication, which is also relevant in the area of arbitrations. So it's an area where there are a lot of developments. I mean, in terms of what we're talking about today and the theme of the conference, which is hard walls and how to get around them, we're looking at some pretty hard walls, and we're looking, I think, at some pretty limited circumstances in which they might be circumvented. Anyway, dealing with the first stage then of the 3 that Lexa took us to a moment ago, if we could have the next slide, please, Hayley. Overall, the courts have adopted 2 different tests when it comes to deciding whether or not to dismiss a winding up petition or to grant an injunction to restrain the presentation of the petition where there is an arbitration clause in play. The first standard, the prima facie standard of review, is actually very simple in one sense to apply. It simply asks the question, is there a valid arbitration agreement between the parties? And then asks the question whether the dispute falls within the terms of that arbitration agreement, and asks no other questions. And if those questions are both answered in the affirmative, grants the injunction or dismisses the winding up petition. The second approach is the common approach in any case where there's a petition debt or a debt potentially being proceeded with by way of winding up or insolvency proceedings, which is the substantial dispute standard of review, which is whether or not the debt is disputed in good faith and on substantial grounds. And there's been a great deal of debate in various jurisdictions over the last few years as to which of the 2 standards of review should apply. And even though those 2 alternatives appear to be quite stark alternatives, and certainly the prima facie standard review suggests that the extent to which the court might retain any kind of discretion to decide what is right in the circumstances, that discretion is really very limited, or no discretion at all. In fact, we can see from the cases we're going to look at, there's actually been a development whereby, although the courts have stated what might be seen as quite a hard and fast rule in terms of the prima facie standard review, has left open the opportunity perhaps for a rather more discretionary approach to whether or not it should be applied. Anyway, dealing with the standard review, and I'm going to just talk before, if we have the next slide, please. Before we come on to the Court of Appeal case in Salford Estates, if we just start with a decision of Mr. Justice Warren, which is actually not on the slide, but it's the Rusant Limited and Traxis Far East Limited case. And the question in that case was the question that arises in all these cases, which is that if you have a debt that's based upon a contract which is subject to an arbitration clause, what jurisdiction do you engage if you want to restrain a winding up petition or seek dismissal of a winding up petition? Is it the insolvency jurisdiction of the Companies Court, or is it the jurisdiction under Section 9 of the Arbitration Act? And in that case, Mr. Justice Warren said that it was, in the first instance, it was the Arbitration Act, but if he was wrong about that, it was the Companies Court. And obviously, if it's the Arbitration Act, circumstances in which there's a discretion is very much more limited. So in that case, both bases were found to be available, but that certainly is not the approach that the Court of Appeal took in the Salford Estates case, which is really the start of all of the cases dealing with restraining presentation or dismissing a winding up petition based on a debt from a contract which is subject to an arbitration clause. Lexa, do you want to say something about Salford, and then we'll both talk about Anna?
Yeah, well, I mean, Salford was an interesting case because it was really the first case where this issue really got sort of people got to grips with this issue. The facts there, very briefly, was that there was an arbitration clause in a lease, and the lessor felt that the lessee owed it some money, and not surprisingly, presented a winding up petition because he thought that was the easiest way of getting the company wound up and probably getting hold of the property again. And the company argued that the debt was disputed and should be referred to arbitration, and the Court of Appeal agreed with the company, and effectively the Court of Appeal said that when you have an arbitration clause, the usual test as to whether the debt is bona fide and disputed on substantial grounds doesn't come into it. If one party says that the debt is disputed, then there will be no winding up order, and that is even if the party that has said that the debt is disputed hasn't referred the dispute to arbitration, has done absolutely diddly squat. I must say, I mean, I'm not in favour of this line of cases which all favour arbitration, and Dan knows I have a sneaking suspicion it's because all these judges quite fancy themselves as arbitrators when they retire, or they fancy their mates being arbitrators, because it just doesn't make sense when you've got a company that really, if you look into it in the slightest bit of detail, owes the money, where the company on the face of it looks to be insolvent, that the court says, oh no, you've got, just because the parties have agreed, I mean, that's the basis of the decision, the parties have agreed that they will submit their disputes to arbitration, the court says, no, we won't make a winding up order, you'll have to go off and arbitrate.
The crazy thing about it,
go on, Dan.
The crazy thing about it is that when you look at the submissions for the appellant in Salford, Leslie Anderson, her submissions are all the submissions as an insolvency lawyer you'd expect to see someone making. That, winding up proceedings aren't a claim, they're a class remedy, so Section 9 doesn't apply. And you'd have thought, standing back, that's a pretty good argument. But the Court of Appeal wasn't impressed. And obviously wasn't impressed because they were concerned about parties using this for collateral advantage, I think, in seeking to put disputes properly before an arbitration tribunal, before the courts on a summary basis, on an application, for example, to restrain a winding up petition. Sorry, Lexa, I interrupted you. I got excited.
No, I think you're absolutely right. And of course, I think they were also concerned about cutting across the prohibition that was introduced by the 1996 Arbitration Act, which effectively prevented parties from applying for summary judgment in relation to a claim that was subject to an arbitration clause. Prior to the 1996 Act, that was a way of getting around being forced to go to arbitration if you could demonstrate on a summary basis that there was really no dispute. The 1996 Arbitration Act stopped that. And I suppose, you know, the winding up jurisdiction would have cut across that. But nevertheless, as Dan just intimated, there are other policy considerations at play when you have a winding up petition. But clearly arbitration holds sway. Do you want to discuss the Annan case?
Yeah, because I think it's fair to say after Salford, the next, apart from the Field-Fisher case we've referred to in our slides, I think all we need to say about that is that what holds good for winding up also holds good for administration. When you get to Annan, the decision of the Singapore Court of Appeal in April, you have basically an examination of all of the arguments for and against the prima facie test and the substantial dispute test, including a survey of all the different jurisdictions around the world where that debate has been played out. And where the Supreme Court in Singapore end up is that the prima facie test applies, but they recognise both that there are exceptional circumstances. In Salford, the test was wholly exceptional circumstances. In the Singapore case, they didn't go quite that far. They looked for abuse of process as the escape valve, if you like, for where the court might exercise some judgments as to whether or not to grant the stay, for example. But also suggested perhaps practical measures which could be taken in order for the test as to whether or not a petition is being brought legitimately. For example, staying the injunction application pending the commencement of arbitration proceedings, practical procedural steps like that. But where they end up is actually quite a curious place, because they end up saying, well, regardless of all of that, the arbitration agreement holds sway. It's subject to exceptions on the abuse of process basis. So you ask yourself in Salford, what is a wholly exceptional circumstance? And the Court of Appeal doesn't really help us. It doesn't say what that might be.
Right, so what the Court of Appeal says he can't think of any.
No.
Thank you, Court of Appeal.
As I think we said earlier, Lexa, when we were talking about this, I think what the Court of Appeal were very conscious of was that they set themselves an incredibly tough test, an incredibly hard wall, if you like, in terms of the arbitration clause point, and just wanted some kind of escape valve in case that ever went wrong and there was manifest injustice being brought about as a result. But what you find, why that's difficult is it's very hard to find a principled solution to what are the circumstances in which you can raise exceptional circumstances to get around it. And one of the things the Court of Appeal in Singapore was very clear about was that if you have an incredibly strong case which is not legitimately disputed or even admitted, that's not going to get you very far, because that's a merits-based argument, and they're very, very keen to avoid any examination of the merits of a case which should probably be before the tribunal. I think where they end up in terms of the exceptions are really the sort of exceptions that it's easy to see working in principle, but quite hard to see working in practice. So they give the example of a company that's up to no good and dissipating its assets, or preferring certain creditors over others. I mean, one can see that is a good reason to apply an exception. But in practice, how often is that going to come up? How often does a creditor have that kind of insight or knowledge into what a company's doing? I think almost never. So again, it's very, very hard to see how the exceptional, or rather the abuse of process test would actually work in practice.
The other thing is, I think, is that really deciding and distinguishing between the two tests. I mean, the test in Annan Group and South Estates, I suppose, is there a prima facie dispute which is bona fide disputed? I mean, that was the test, and which is not an abuse of process. Or the normal winding up process, is the debt bona fide disputed on substantial grounds? I mean, it is like dancing on the top of a pin, isn't it? I mean, what is the difference between the two tests? And I think it was you, Dan, you said that Warren said that the bona fide dispute can be a shadowy dispute.
Yeah, yeah.
Very, very difficult, I think.
Maybe the point of a dispute, Lexa, is it's very good for the lawyers.
Yes. Yeah, well,
as well as the arbitrators. But anyway, should we just briefly mention Telnik?
Well, yes, except that we can't believe that you mentioned Telnik. We can't believe that it's as set out in the digest. But
because anyway. we were pretty convinced we knew where we were up until about yesterday. Actually, there's a bit before. It was a couple of days ago. It was last week. I'm pretty sure we knew that there are circumstances really in which the court could look at the merits of the dispute where there was an arbitration clause was very limited. But then there is it's a report on, I think there's a report on Lawtel and a report on Westlaw, but we don't actually have the judgment from the Chancellor where he had before him an application for permission to appeal on various grounds from a decision to grant an injunction to restrain the presentation of a winding up petition. There was an appeal on the ground the judge had been wrong to hold there were no special or exceptional circumstances requiring the court to decide whether the petition debt was disputed on substantial grounds. Sorry, if I might have put that wrong a moment ago. It was actually a refusal of an injunction. And the creditor argued there were exceptional circumstances, according to the report, which justified the court considering whether T, that's the debtor, disputed the petition debt on substantial grounds, namely that the debtor was insolvent irrespective of his petition debt, it had made an unsuccessful application for a stay at the arbitration proceedings, and it appeared unwilling to properly engage in the arbitration. So that, they said, according to the report, allowed them to look at the merits of the case. Permission to appeal was granted, and what the report says is that Salford, the Court of Appeal case, did not establish that a court could not inquire into whether a debt that was subject to arbitration proceedings was disputed in good faith or on substantial grounds. Now, that seems to us to, I think, be the absolute opposite of what Salford actually says. So we'd be quite surprised if I think permission was granted on that basis. While accepting, of course, that exceptional or wholly exceptional circumstances might enable the court to look at the merits, but that's something that's out there at the moment, anyway, in terms of an appeal to the Court of Appeal.
Shall we move on now, because we're running away with ourselves on stage two. So stage two is where a company has gone into liquidation, but there were already existing arbitration proceedings.
Should we have the next slide? Sorry, Lexa.
Yes, sorry. Yes. Can we have the next slide? Yeah, there we are. And so companies already gone into a form of insolvency process, but arbitration proceedings were already on foot at the time that the company went into the insolvency proceedings. Now, both in the UK and in Jersey, there are various automatic stays when a company enters any kind of insolvency process. In England, I don't think that does apply in Jersey, but correct me if I'm wrong. When you've got a creditor's voluntary liquidation, there is no automatic stay in England, but obviously a liquidator can apply for a stay. Now, it's not an area that's been a subject of any sustained consideration. In fact, the cases where the issue has been considered, they are cases where you've got a situation where a foreign company is in an insolvency process in a different jurisdiction, and the arbitration proceedings are being conducted in the UK. And a recent case in that area is a case before the ICC courts in the UK, and the ICC Judge Jones in a case called H&CS Holdings. Can you just move on to the next slide, please? H&CS Holdings and Glencore International. That was a case where H&CS Holdings was in liquidation in Singapore. An arbitration was in progress in London between H&CS and Glencore, and the office holder of the Singapore company, H&CS, came to the UK and applied for recognition in the UK with the precise purpose of getting a stay of the arbitration proceedings because of the automatic stay once you get recognition. Anyway, ICC Judge Jones, with an absolute straight face, obviously recognised the foreign insolvency proceedings under the model law, and so an automatic stay was imposed. But then he immediately lifted the automatic stay to allow the arbitration to continue in London. So not much good it did the Singapore office holder. In so doing, he followed a much earlier case in 2011 of Mr. Justice Briggs, as he then was, called Costco Bulk Carrier Company and Armada Shipping. And there the proceedings that were ongoing were in Switzerland, and exactly the same thing happened. The Swiss office holder came, got recognition, but then Mr. Justice Briggs was persuaded that actually the automatic stay that would otherwise apply should be lifted in relation to an ongoing arbitration in London, because it was felt that it was in the interests of the insolvency proceedings that the arbitration continue, which is interesting. So it wasn't the arbitration must continue because arbitration trumps insolvency proceedings. Actually, what the court did, both in Armada and in the H&CS Holdings case, is one of the factors that it took into account was whether it was in the interests of the insolvency proceedings to allow the arbitration to continue. Now, I think what we want to do now is just deal with our stage 3, if we can, which is on the same slide.
I just say something.
Remember, is where you've got the company that's gone into liquidation and a creditor has a claim, and the question is, which is subject to an arbitration clause, and the question is, does the claim, is the claim going to be resolved by arbitration, or is it going to be resolved by submitting a proof of debt in the liquidation? Dan, do you want to say something about this?
If we just say very briefly about the decision of His Honour Judge Pearl QC in the Philpott case. And that was a case, it was a building dispute between a school and a construction company. And it was, there was a contract with JCT terms, it provided for adjudication and arbitration. The builders wanted to, they were seeking payment, but the question was, in an insolvency context, because the builders had gone into insolvency, whether or not insolvency set-off prevented the arbitration route being taken, and whether or not the fact that there was an arbitration clause simply prevented the appeal process from a proof of debt. So what the builders could have done is they could have put in a proof, the liquidators could have adjudicated, and the school could have put in proof, could have adjudicated, and then there would have been a determination which could be subject to an appeal. And what His Honour Judge Pearl QC found was that the appeal process was itself proceedings for the purposes of Section 9 of the Arbitration Act, and that therefore, as convenient and as quick and as easy as it might be, query that, because those appeals aren't always quite so quick and easy as you might expect, the correct approach was indeed to go down the arbitration route. And that was really taken up, I think it's fair to say, by Bresco, certainly in the Court of Appeal, where Philpott was referred to. Bresco is a case about adjudication proceedings, but equally the Court of Appeal said would apply in the context of arbitration as well. And what emerges from Bresco is there are really two parts to the judgment in the Supreme Court. The first part is the jurisdictional argument, which is whether or not it's open to do anything other than have the arbitration or the adjudication. And it's clear from what the Supreme Court says, jurisdictionally it's preferable to go down the arbitration adjudication route. That's the correct approach. But alternatively, is it futile? Is it pointless? Is it in some way an inefficient way of going about things to go down that route? And again, that's something which the Supreme Court rejected. The argument that the whole process was futile anyway, because an adjudication was just a temporary decision.
I'm just going to come in here because I've got a bit of a problem with these decisions, because in the context of insolvency. And the reason for this is because, you know, often a liquidator just doesn't have the funds to arbitrate. So a creditor could actually go off, arbitrate its claim, get an award which is completely unrealistically completely over the top, and then submit a proof of debt. What happens in those circumstances? Is the liquidator bound by that award because he should have joined in the arbitration, or can the liquidator revisit the award through the proof of debt process? The other problem is that, of course, we all know that under the proof of debt process, a creditor, a third-party creditor, can challenge the proof. If in circumstances where the liquidator has engaged in the arbitration and there has been an arbitration award, can a third-party creditor challenge that award on the basis that actually the arbitrator got it totally wrong? I mean, the ability to appeal arbitration awards is extremely restricted, as I know, to my cost. But is the right of a creditor to challenge the award through the proof of debt process similarly restricted? There are lots of unanswered questions here. And finally, the other thing is that if a creditor who has the benefit of an arbitration clause submits a proof of debt in the insolvency, could it be said, aha, you've submitted to the insolvency proceedings and therefore you've elected to choose the proof of debt procedure over going for arbitration, and therefore you're to be kept up to your election, much as happened in the Eurofinance and Rubin case. Well, actually it was the UKAC part of the decision, where it was held that the creditor who had submitted a proof of debt in the liquidation had actually submitted to the jurisdiction of the liquidation. So there's lots of really unanswered questions there, which, I mean, nobody really has grappled with.
I think it's one of the things about this being an area where things are moving so quickly that maybe policy decisions made in terms of hard statements of principle, the practicalities of them really haven't been thought through at all.
The last case on the list is Norrie Holding. We haven't got much time to talk about it, but that's another interesting case where what happened there was that the proceedings were insolvency proceedings in Russia. A claim was started against a creditor by the insolvency office holder of the Russian bank in Russia. It was a claim that really we would characterise as a transactions and undervalue claim in the UK. And the claimants in the UK, i.e. the creditors who were being sued in Russia, came to the UK and sought an anti-suit injunction in the UK to restrain the office holder in Russia from continuing the proceedings in Russia, because it was said that the dispute was subject to an arbitration clause. And the UK court granted the anti-suit injunction. And there's an interesting discussion as to whether a claim which is equivalent to a transaction is under value, so an insolvency claim, is an arbitral claim. The English court said, well, if the arbitration clause is wide enough, yes, it can be comprised within an arbitration. I think we've got to the end of our...
I think we've occupied our allotted time.
Or a gallop, even. Happy to take any questions if anybody's got any. Oh, yeah, there's one there, I can see.
I will answer that live. Well, I'll press the answer live button, Lexa, so that will come up on the screen for you.
Yeah. So the question is, re-arbitration involving a company which is already in liquidation, why don't these decisions fall foul of the general rule that you can't contract out of the effect of the insolvency legislation, for precisely the reason identified by Lexa, that the costs involved prejudice the other creditors? Do you want to have a go, Dan, or shall I?
I'm not quite sure what the answer is. I mean, I'm not sure. I'm not sure that the way it's been dealt with so far has really dealt with that argument at all.
No.
But the way the courts, I mean, the way the court in Singapore dealt with arguments about arbitration is hard for insolvency and that kind of argument, is to say, actually, arbitration is an incredibly good thing, and it's very quick and very cheap, so everyone should be in favour of it. So to answer the question, but I'm not quite sure how you deal with. I don't think it's avoidance of insolvency provisions per se, but practically.
I think it's actually quite a good point, because what the parties are doing is that they're saying, we're not, you know, pre insolvency, we have agreed that if we have a dispute, it will be done in private by, you know, an arbitrator who could be, you know, Uncle Tom Cobley and all, and nobody necessarily can get to know the reasons for the award. Yeah. So it is contracting out of the insolvency legislation. It's a good point. I don't think that it's really been addressed in any of the cases that I've read. I mean, the point was made in the Singapore case, that you know, winding up is a sort of public interest policy jurisdiction. And it was a class remedy, and it's a class remedy, and the court wasn't having any of that, and they were saying that anybody that presents a winding up petition just wants its debt paid, which is actually very different generally from the way that the English court. I mean, the English courts do pay lip service.
A class remedy.
A class remedy, but the Singapore courts weren't having any of it. So, yeah, that's a really good question. Yeah, it's an interesting one. Anybody else got any questions? No? Well, thank you everybody for listening in. This was a novel experience for me as well. Well, hope to see you all again in person sometime. You know, I feel like singing "We'll meet again, don't know where, don't know when." But, yes, well, enough of my voice. But thank you, everybody, very much.
Yeah, absolutely. Just to echo that, thank you, Lexa and Daniel, for a very interesting discussion, and thank you to Clare as well, and thank you to all of you, the 50 or so of you who've joined us today. As I mentioned at the outset, we are hosting a second webinar tomorrow. That has more of a trust focus, although with a twist that we will be comparing the duties of disclosure that are owed by trustees in blessing applications to those owed by way of the duty of full and frank disclosure in commercial ex parte applications, such as applications for freezing orders. And Terry Marshenson and Bobby Freeman will be taking you through the ex parte commercial half of the talk, And then Jonathan Hilliard and Simon Atkinson will be comparing that to trustee blessing applications. I should say, if there's anything that that occurs to you after the talk, please do feel free to email any of us and we'll get back to you. Our email addresses are up on the Wilberforce website. And I think that just leaves me to say that, as echoing Lexa, that we hope to see you all in person soon, and that you all stay safe and well in the meantime, and have a good afternoon.